think you're okay, you're set up to do it. Yeah, you definitely want.
Olympian, this is Pam Hartman-Beyer, the court administrator. Can you identify yourself, please?
Hi, this is Martine with the Olympian.
Hi, Martine. I'm sorry. We have it also YouTube. We're having it. This is very difficult because it's playing on YouTube as well. We're having. Can you just pull that down, please, Liz? It's okay. We're going to send you a link for YouTube via email. We are having via media watch via YouTube and not on this link. So
Okay.
we'll send that to you via email in about 2 seconds, okay?
Okay, I'd appreciate that. Thank you.
Bye.
This is Steve. I just wanted to tell you, you probably expected this at the PDA. Okay, you're welcome. Can you have your mouse on, please, in the courtroom?
Definitely.
Touch the camera on me. Hey, don't be.
Sorry? Board administration has it. The first
It
window.
would have been on the order setting this meeting.
Well, for a Zoom, but I just was talking about just the YouTube.
You're good? Good?
Thank you.
I feel a bit very, thank you, sir.
Oh, I think,
Very good. Can you handle me now?
thank you.
You're welcome.
Steve? Hey,
Yes.
Steve. Hey, can you see if the real time is working? It should be. It was working from this morning's hearing. I was with him on him in this courtroom.
Yeah, just a second.
I see it just connected, it looks like.
Yeah, it's
Thanks, Steve.
you're welcome. Yeah. Should be. All rise. Superior Court for the State of Washington is now in session. The Honorable James J. Dixon presiding.
Please be seated. Thank you. Court is on the record in the matter of State of Washington versus Tim Eyman et al., cause number 17-2-01546-34. Before the court begins its ruling this afternoon, the court will advise the parties and the public that the court's decision this afternoon is being live streamed. I'll give you the site so that you can pass that on to anyone who might be interested. The site on YouTube is 17-2-01546-34, State of Washington versus, that's VS period, Tim Eyman, comma, et E period, all AL period. 17-2-01546-34, State of Washington versus Tim Eyman, comma, et al. Court has also been advised this afternoon, or actually this morning, that there are media members present, either in person or appearing remotely, who are seeking permission from the court pursuant to General Rule 16 to video and or audio record and or photograph proceedings this afternoon. So pursuant to the court rule, the court will invite members of the media to address the court and make any requests. Sir, good afternoon.
Your Honor, I'm Ted Warren, Associated Press.
Thank you.
Glenn Morgan with We the Govern, just still photos.
Thank you.
Charlie Curie, I contribute to the Thurston County Scanner News and video.
Okay, thank you. Any media appearing remotely? Okay, turning first to the state, Mr. Newman, any objection to media photographing and or audio recording the proceedings?
No, Your Honor, and just so Your Honor knows, I think somebody from the Olympian was on the Zoom and they were asked to switch to the YouTube.
Okay.
So somebody from the Olympian was on. I don't know if that matters to you, but no objections.
Thank you. Mr. Sanders, any objection to the media presence and recording the hearing this afternoon? Can't hear you.
Can you hear me now, Your Honor?
I can, thanks.
I have no objection.
Okay, thank you. So the court grants that permission, and pursuant to the court rule, the court will remind those members of the media what they probably already know. Media personnel shall not, by their appearance or conduct, distract participants in the proceedings or otherwise adversely affect the dignity and fairness of the proceedings. And thank you for inquiring in advance. Okay, a couple of comments from the court before the court issues its ruling this afternoon. First, the court has drafted findings of fact and conclusions of law that will, in detail, delineate and specify findings, conclusions, and order of the court. And immediately after the court issues its verbal ruling this afternoon, the court will sign those findings and conclusions and provide them to the clerk of the court so that the clerk can file them, and presumably, I can't speak for the clerk because the clerk doesn't work for the court, but the clerk will make those findings and conclusions available to any person or persons who wish to access findings and conclusions. Of other comments for whatever this is worth. Case has been pending for almost 4 years. Immediately prior to taking the bench this afternoon, I looked at the file, at least the electronic version of the file, and just so that I could refresh my recollection with respect to when this case was filed, it was filed March 31, 2017. And I mention that because it takes a while for civil cases to make their way through the court system, any superior court system, for a variety of different reasons. But it's not because this case has not been actively litigated by all sides. I think it was mentioned by one of the attorneys during closing arguments that they've been in front of me. I forget. I think it was Mr. Newman. I apologize. It was compelling to the court when he mentioned it, how many times they've been in front of me. The parties have been in front of me during these past 4 years. That is evidence that this case has been been contentious. It's been hard fought. And there have been several instances where, at least in this court's opinion, it has been, the court has been invited to weigh into the fray, for lack of a better way to put it. Emotions have run high in this case, and understandably so. This court feels very confident that anyone who has observed the litigation in this case, meaning the court appearances, would, or at least should, agree with the court that this court has remained at all times, maybe with one exception that I can remember at trial, for which I now apologize, but has remained calm and reflective, and has respectfully declined the sometimes not so subtle invitations to join the contentious nature of the case. And the reason I mention that is because this is a political case, and it's not a political case. This is a case involving statutes that relate to the political process in Washington State. So in that sense, this is a political case. It is not a political case in the sense that, or as that term might be used in the common interpretation or the common understanding of the public. What I'm trying to say, and I'm not being very articulate here, but what I'm trying to say is that this case involves politics. It is the obligation of the court to apply the facts to the law. This court does not get involved in in a party's political leanings or sensitivities, and it would be error for the court to do that. Again, it's the responsibility of this court to simply apply the facts as the court finds those facts to the law. And that's what the court has done. I feel very confident about that. And I'll make my findings of fact today. I'll also make conclusions of law today, and I'll enter an order today that reflects the court's ruling. The Washington State Constitution was adopted in 1889. It did not initially contain provisions for initiative or referendum. Article 2, Section 1 provided in part, quote, ... the legislative powers shall be vested in a Senate and House of Representatives, close quote. Excuse me. In 1911, the Washington legislature proposed Amendment 7 to Article 2, Section 1, which provided in part, comma, quote, ... the legislative authority of the state of Washington shall be vested in the legislature, consisting of a Senate and House of Representatives, which shall be called the legislature of the state of Washington, but the people reserve to themselves the power to propose bills and laws, and to enact or reject the same at the polls, independent of legislature, and also reserve power at their own option to approve or reject at the polls any act, item, section, or part of any bill, act, or law passed by the legislature. Close quote. Hence, the birth of the initiative process in Washington state. And to quote two great philosophers, Huey Newton and John Lennon, power to the people. Interestingly, the state's campaign finance disclosure law, also known and codified as the Fair Campaign Practices Act, was adopted via initiative, specifically Initiative 276 in 1972. That initiative declared, quote, "The public's right to know of the financing of political campaigns far outweighs any right that these matters remain secret and private," close quote. I'm going to repeat that. The public's right to know of the financing of political campaigns far outweighs any right that these matters remain secret and private. This ballot measure was overwhelmingly approved by the voters of Washington state. And when I say overwhelmingly, by specifically 72% of Washington voters approved that ballot measure, and it was enacted or codified January 1, 1973. Mr. Eyman has a long and, well, at least on a relative scale, history of political involvement and some might say activism. And the court uses that latter term not in a pejorative sense, but in a real sense, activism. He's been active in the political world. Thousands of people in this state have actively and financially supported Mr. Eyman and initiatives he has sponsored or supported. That is public knowledge, and it is also evidence well established at trial. Some of the individuals who testified during this trial have impressed upon this court their personal and financial support of Mr. Eyman for a variety of reasons. They, at least the people who testified in court during the trial, were hopeful that their support would remain anonymous, or at least that they would never be called to testify in a public trial. I mention that because the court wishes to at least attempt to stress to these people that their actions and exercises of their rights are not at issue. Everyone has a right to support a political cause. During trial, testimony from some of these individuals was unfortunately uncomfortable, if not contentious, and that's unfortunate. But as I mentioned during trial, we are not sitting around the kitchen table. That's the phrase that I used during trial when I was addressing one of the witnesses. Rather, the court has an obligation to abide by certain rules, and once an individual is subpoenaed by a party to appear in court, that individual takes a witness stand, and those aforementioned rules apply. I feel compelled to mention this because it was clear to the court that some of the witnesses felt, and probably still feel, very strongly about their rights to privacy. And I'll leave it at that. So let me start with this finding. Mr. Eyman is a, quote, continuing political committee, close quote, as that term is clearly defined both in statute and in case law. Political committee is defined as any person except a candidate having the expectation of receiving contributions or making expenditures in support of or opposition to any candidate or ballot proposition. Court cites RCW 4217A005 subsection 40. The term person is broadly defined to include an individual. Same statute at subsection 38. As such, Mr. Eyman had a legal duty to comply with the applicable provisions of the Fair Campaign Practices Act. When an entity becomes a political committee, it is required to file a statement of organization with the PDC, Public Disclosure Commission, and make a variety of detailed disclosures. Court cites the case of Utter versus Building Industrial Insurance of Washington 182, Washington 2nd 398 at page 413, 2015. These disclosures are posted on the PDC's website, which, quote, enables the public to follow the money with respect to campaigns and lobbying. The court cites Human Life of Washington, Inc. versus Brumsicle, BRUMSICKLE. 624, Federal 3rd, 990 at page 997, 2010. In 2002, Mr. Eyman admitted to violations of the Fair Campaign Practices Act and stated that he had established a political action committee, Permanent Offense, Inc. Quote, to have a way to cover the fact that I was making money supporting initiatives and none of my co-sponsors knew that was the case, close quote. As a result of that lawsuit, Mr. Eyman was permanently enjoined from acting as a treasurer and as a signer or on any financial documents of any political committee. In the instant case, there are 5 central claims or allegations raised by the state, and I will address all 5 of those series of claims. I'll do it in a summary fashion, and again, the court's detailed ruling will be included in its formal findings of fact and conclusions of law. First, with respect to the state's claim of concealment of costs and expenditures related to the I-1185 campaign. Mr. Eyman's political committee, Voters Want More Choices, and others paid Citizen Solutions LLC, a signature gathering company, $1.25 million to gather signatures to qualify for the 2012 ballot. Mr. Eyman and Mr. Agazarm agreed upon an increase in prices paid for signatures for the purpose of gaining extra money that was designed and resulted in that money ultimately going back to Mr. Eyman. Mr. Eyman contacted contributors to gather extra money to procure more signatures when, in fact, the signature gathering was already paid for. There was, in fact, no shortfall. In addition, during this time, Mr. Eyman was engaged in a scheme to generate money to be paid to him from Citizen Solutions for work he was doing to solicit political contributions. This ultimately led to Citizen Solutions paying $308,000 and change to Mr. Eyman's solely held committee and ultimately to himself. This payment was made with the intent to violate the Fair Campaigns Practices Act by concealing the purpose of expenditures of donor funds to support I-1185. Claim number 2. This relates to the Initiative 517 concealment issues. The court finds that Mr. Eyman planned to fund the I-517 signature gathering partially through the money he received back from Citizen Solutions. He funneled or laundered some of that money through Citizens in Charge without reporting it to the Public Disclosure Committee. And that total was, I think, $482,806.
I believe that might be a typo. It's 182.
It's 182.
806.
$182,000, excuse me, $182,806. The court finds this was an intentional violation of RCW 4217A 435. With respect to the state's claim number 3, dealing with alleged concealed payments, the court finds that during the time period from 2013 to 2018, Mr. Eyman solicited and accepted money from thousands of individuals, businesses, and other entities. These solicitations were made with the expectation of receiving funds to further his work on ballot propositions. Moreover, some of those checks were made payable to the 2/3 Constitutional Amendment Initiative Committee, deposited into Mr. Eyman's personal bank account, and used for personal reasons. This court previously found, as a discovery sanction, that payments totaling $766,447 were contributions in support of ballot propositions. This court also finds, based on the evidence produced at trial, that the $766,447 and $71,055 were contributions in support of ballot propositions. These amounts were not reported to the Public Disclosure Commission in violation of RCW 4217A 235, 240, and 435. With respect to the state's claim number 4, regarding misappropriation of a $23,000 refund, it's $23,008.93. That's a refund that was from DataBar to Voters Want More Choices. This court finds that that refund from the mailing service was paid to Mr. Eyman's company, Watchdog, at Mr. Eyman's request, as opposed to Voters Want More Choices. Mr. Eyman then transferred that money to his own account. With respect to the state's claims of reporting violations, this court finds that as of November 16, 2020, Mr. Eyman failed to register as a political committee. As of the beginning of trial, he was 2,975 days late. This court finds that Mr. Eyman received contributions in support of ballot propositions in 58 separate months. He failed to file C3 and C4 reports on 124 occasions. The court also finds that Mr. Eyman failed to register with the Public Disclosure Commission. That is a violation of the Fair Campaigns Practices Act. As detailed in the conclusions of law that will be entered by this court, the total base penalty established by the facts produced at trial is $5,754,987.43. This court concludes that the appropriate and proper penalty is $2,601,502.81. $2,601,502.81 as detailed in the court's conclusion of law 3.15. This court finds and concludes that Mr. Eyman's violations of the Fair Campaigns Practices Act are numerous and particularly egregious and were, quote, intentional, close quote, as that term is defined by law. That definition is, quote, the intent to accomplish an unlawful act, quote, but there is no requirement that the actor have subjective knowledge that the act itself is unlawful. Court finds that the series of violations were knowing and intentional efforts to conceal, deceive, and mislead, and were collusive in nature. The court finds that Mr. Eyman's violations had a significant and material impact on the public. The court finds that Mr. Eyman's violations occurred despite his experience with campaign laws and procedures. Indeed, Mr. Eyman has been engaged in campaign laws and procedures and political activity for more than 20 years. The court finds that Mr. Eyman has personally benefited economically from these violations. The court finds that Mr. Eyman, watchdog for taxpayers, the defendant, Tim Eyman, watchdog for taxpayers, accepted the referenced $308,185.50 from Citizen Solutions on behalf of Mr. Eyman and thereby violated RCW 42.17a.435. Accordingly, the court assesses a $10,000 penalty against that entity as authorized by that statute. This court declines to treble damages as requested by the state and as authorized by law. Specifically, RCW 42.17a.780. The state Supreme Court recently noted, quote, we direct trial courts to use care when exercising their discretion to determine whether a violation of the FCPA warrants treble damages, close quote. The court cites State v. Grocery Manufacturers Association, 195 Washington 2nd, 442 at page 473. That's a 2020 case. That court also held, quote, each case shall be assessed individually and with great care, close quote. The court in Grocery Manufacturers Association set forth a list of non-exclusive factors for the court to consider when determining whether treble damages was appropriate. Those factors include, was the act or acts intentionally? In this case, the court finds yes. Were they egregious and willful? In this case, the court finds yes. Did the acts result in injury to the public? In this case, the court answers that in the affirmative. Did the acts result in financial gain to the offending party? In this case, the court holds yes. Did the violator have a prior history of noncompliance? This court finds yes. And finally, what was the level of cooperation with the Public Disclosure Commission? The court declines to rule or make a finding with respect to that particular issue because it's unclear to the court, based on the evidence produced at trial, what Mr. Eyman's, quote, level of cooperation close quote, was with the PDC. Moreover, the Eighth Amendment and Article 1, Section 14 of the state constitution prohibits the imposition of, quote, excessive fines, close quote. A fine is excessive if it is grossly disproportional to the gravity of the offense. The court cites the United States Supreme Court case of United States versus, I'll spell it, BAJAKAJIAN, 524 U.S. 321 at page 334, a 1998 case. This court also notes that the United States Supreme Court, in its decision rendered in Timbs, T-I-M-B-S versus Indiana, found that the Eighth Amendment applies to civil cases, at least in a liberal interpretation, and more specifically, at least as it relates to forfeitures, which are quasi-criminal in nature. But a liberal interpretation of the United States Supreme Court decision that I referenced moments ago results in this court finding that the Eighth Amendment applies in certain circumstances to civil cases, and the court will exercise its discretion and decline to treble damages. With respect to the injunctive relief sought by the state, court grants the injunctive relief sought by the state, and the court's order with respect to injunction will be included in its findings and conclusions beginning on page 30 at line 7 and ending on page 32. The court enters an injunction from today's date and into the future with respect to any fundraising activity. Mr. Eyman is enjoined from misleading contributors or potential donors, directly or indirectly, as to why they should donate to a political campaign or how any contributions will be spent. The court enjoins Mr. Eyman from receiving payments from any person or vendor, directly or indirectly, who has provided or plans to provide paid services to a political committee from which defendant Eyman is associated or of which he is a member. The court enjoins Mr. Eyman or requires Mr. Eyman to comply with the Federal Campaigns Practices Act and report any gifts, donations, or any other funds that Mr. Eyman receives directly or indirectly, unless those funds are segregated and used only to pay for legal defense, or such payments were from an employer and the employer shall issue a W-2 that includes all funds paid only so long as payments made by the employer for work are otherwise reported in compliance with the Fair Campaigns Practices Act. The court enjoins Mr. Eyman from managing, controlling, negotiating, or directing financial transactions of any kind for any committee, as that term is defined by statute, specifically RCW 42.17a.005. The court also includes in its findings and conclusions detailed injunctions 1 through 11, beginning at page 31. They include, but are not limited to, an injunction prohibiting Mr. Eyman from being named in a statement of organization as a treasurer or deputy treasurer. He shall not have the authority or responsibility for approving disclosure statements, that he shall not be named in a statement of organization filed with the PDC as an individual who may authorize expenditures, shall not be listed as an account holder on any banking or other account that holds political committee funds, He shall not control nor be a part of any entity that controls or accept or take possession in any manner any contributions intended to support a political committee. Mr. Eyman shall not have the authority to bind a political committee as a speaking agent with respect to expenditures to be made. Accepting payments from his personal funds made as in-kind contributions, Mr. Eyman shall not have any financial decision-making authority for any political committee. He shall not approve or participate in the decision-making for the approval of transfer of funds from one political committee to another. Mr. Eyman shall not directly solicit contributions for himself or his family to support his political work without establishing a political committee, which must report those contributions to the Public Disclosure Committee. If Mr. Eyman loans money to a political committee, the terms of the loan must be in writing, signed by Mr. Eyman and an authorized member of the political committee who cannot be Mr. Eyman. And finally, Mr. Eyman shall not direct or solicit payments from contributors directly to campaign vendors. And the injunctions entered by the court are in much greater detail and included in the findings and conclusions to be entered with the court. The court dismisses Mr. Eyman's counterclaims based upon the evidence at trial. The court makes a finding that the injunctive relief or the injunctions entered by the court do not violate Mr. Eyman's constitutional rights, including but not limited to his First Amendment rights. Finally, a comment with respect to a disagreement from the parties with respect to the consequences of Mr. Eyman, and more specifically, whether any injunctive relief sought by the state and entered by the court would violate Mr. Eyman's rights, more specifically as it relates to the First Amendment. And even more specifically, the argument raised by Mr. Eyman that the entry or the granting of injunctive relief would preclude or prohibit either as a matter of law or as a matter of practicality, Mr. Eyman from continuing to be politically active and involved in his profession, which no doubt is his passion, both politically and professionally. This court wants the record to be clear and for the parties to be clear, hopefully, that the injunction entered by the court does not stop Mr. Eyman from doing what Mr. Eyman wants to do, in the sense that Mr. Eyman can continue to be involved in the political process in a manner that is authorized by law. He just has to comply with the law. He has to comply with the provisions of the Fair Campaigns Practices Act. And he hasn't. And again, I'll say it for the third or fourth time, the court's findings and conclusions will be in much more detail in its written findings and conclusions. In any action brought under the Fair Campaigns Practices Act, the court may award to the state all costs of investigation at trial, including reasonable attorney's fees to be fixed by the court. So the court will require the state to, if they are so inclined, to file whatever appropriate pleadings and motions it believes are necessary if it seeks recoupment of attorney's fees and costs, and the court will make that decision at a later date after a hearing. The court concludes its ruling this afternoon by thanking the parties that were involved in this case, thanking the attorneys for their professionalism, so thanking Mr. Eyman for his, maybe I would be remiss if I didn't mention this. I've done it on a handful of occasions during the pendency of this trial. The court feels no ill will towards Mr. Eyman. I don't know Mr. Eyman, but he's appeared in front of me on several occasions, too numerous to mention. And on every single one of those occasions, despite some concerns raised by the state, Mr. Eyman has been on time, cordial, professional, polite, respectful. This court means no ill will towards Mr. Eyman. The court has now signed findings and conclusions. We'll ask the deputy clerk to file them. Thank you, everyone. Court is in recess.
All rise.